Natural rights versus statutory privileges. 1. What are natural rights? Natural rights come from classical natural law theory, especially thinkers like John Locke. The basic claim: human beings possess certain rights by virtue of being human, not because a government grants them. Commonly cited examples: life, liberty, property, self-defense, freedom of conscience. These are considered inherent and pre-political. That means they exist before government. Government's role is to protect them, not create them. Under this view, a law that violates natural rights is unjust, even if it is officially enacted. Number 2. What are statutory privileges? Statutory privileges are permissions created by legislation. They exist because a statute creates them, can be limited, regulated, or revoked. Apply within specific jurisdictions. Examples: a driver's license, a professional license, tax exemptions, government benefits, corporate status. These do not exist in nature. They exist because a legislative body enacted them. In modern legal systems, especially in constitutional democracies, courts often distinguish between fundamental rights, constitutionally protected, privileges or benefits, regulated by statute. However, even constitutional rights are enforced through institutional structures. 3. The key difference: natural rights, statutory privileges, inherent, granted, exist prior to government, created by government, cannot morally be revoked, can be revoked by law, grounded in human nature, grounded in legislation, claimed universally, jurisdiction-specific, important nuance. Modern courts do not operate purely on classical natural law. They operate primarily on constitutional and statutory frameworks. So in practice, rights are enforced through legal systems, even if philosophically they are said to be inherent. Part 2. Personal sovereignty versus political sovereignty. This distinction is often misunderstood. Number 1. Personal sovereignty. In philosophical language, personal sovereignty means self-governance, self-ownership. Moral autonomy. It means you are responsible for your actions. You possess agency. You are not property of another. In moral philosophy, this idea connects to autonomy and dignity. In constitutional systems, it is partially reflected in protections like due process, bodily integrity, freedom of belief. But personal sovereignty does not mean exemption from law. It means you are a moral agent under law, not merely an object of control. Number 2. Political sovereignty. Political sovereignty refers to supreme governing authority. In modern systems, sovereignty is typically located in the state, the Constitution, or the people collectively. For example, in the United States, sovereignty is understood to rest ultimately in we the people, constitutional theory, but operational authority is exercised by government institutions. Political sovereignty includes power to legislate, power to tax, power to enforce laws, territorial jurisdiction. Political sovereignty is institutional and territorial. Personal sovereignty is moral and individual. 3. Where confusion often occurs. Some people conflate moral sovereignty with exemption from political authority. Modern legal systems do not recognize individuals as separate sovereign states within territorial jurisdiction. Under contemporary law, individuals are subjects or citizens under a sovereign political structure. Political sovereignty supersedes personal autonomy in matters of public law. However, political authority is theoretically limited by constitutional protections. How they interact in modern political law. Modern systems are hybrid structures. They contain natural rights language, philosophical foundation, constitutional rights, legal codification, statutory privileges, regulatory mechanisms. Personal sovereignty is protected through civil rights, procedural safeguards, constitutional limits on government. Political sovereignty is expressed through legislative authority, executive enforcement, judicial interpretation. The tension between the two creates constitutional law itself. Simplified analogy. Think of a game board. Natural rights, the idea that players inherently deserve fair treatment. Statutory privileges equals special rules created by the game organizer. Personal sovereignty equals your ability to make your own moves. Political sovereignty equals the authority that sets the rules and enforces them. You cannot remove the rule maker and still have a structured game. But if the rule maker violates the foundational principles of fairness, the legitimacy of the game is questioned. Critical clarification. Under modern legal doctrine, natural rights are philosophically foundational, but legally protected only insofar as they are recognized by constitutional structure. Political sovereignty is what courts recognize as enforceable authority. Personal sovereignty is a moral and philosophical concept, not a status that overrides jurisdiction. The deeper question. The real philosophical debate is this: does political sovereignty derive legitimacy from natural rights, or does it create the rights it enforces? Classical natural law says, political authority is legitimate only if aligned with natural rights. Legal positivism says, law is valid because it is enacted by recognized authority. Modern systems operate somewhere between these two poles.